welcome to the CCI Grand River Condominium Podcast. My name is Michelle Dyer, and thank you so much for listening. This is episode 15, and we're talking cat. No, not the furry animal, but the Condominium Authority Tribunal. It sounds ominous, doesn't it? To help make it less scary is Chris Mendes, condominium lawyer with SV Law in Guelph.
Michelle.
Thank you, Chris, for joining me today. Chris wrote an article on a tribunal decision regarding animals in condominiums, and we'll break that down in a few minutes. But let's start with the simple stuff. What is cat?
That's, of course, a very good question. So I'll just take it, before I answer that question, I think I'll just take it one step back.
Sure.
And just to say, so condos in Ontario are governed by the Condominium Act. And the Condominium Act is a piece of legislation from the Ontario government, so we can thank our members of parliament for that. And it sets out essentially an entire code for condominium living. And so, you know, in any situation where people are living in tight-knit communities, there's going to be conflict between those individuals and between the boards of condos, which are, you know, elected by the ownership to help govern that whole condo and help settle disputes that arise, or they have certain obligations that they have to do.
So let me just interrupt you. So the Condo Act supersedes the declaration, bylaw, rules, policies of the condominiums.
Exactly.
Okay.
Yeah. So you're right on the money with that one.
Yeah.
And so as some people may know, is there was a bunch of recent amendments to the Condominium Act.
Yes.
So before those amendments, when there was a dispute between owners and condo boards, or condo boards and a number of unit owners over, you know, things like pets and animals and nuisances and the things that we typically see in tight-knit communities, there was really only two avenues to resolve those disputes, and those could be quite expensive. One was we could go to court,
right,
and have a judge settle the issue.
So at that time, though, when you say go to court, all the parties would have to have their own legal representatives at the time.
So you're not legally required to have a lawyer,
no,
but of course,
yeah.
I mean, the legal system is complex, and you know, often people want a lawyer to guide them through that process, and
right,
of course, make the best arguments.
So back then, you would have all the parties involved in the dispute, and you'd all go to court.
Yeah.
That was one option. What was another option?
Second option was mediation, followed by arbitration.
Still involving lawyers, though.
Still involving lawyers.
Yeah.
So what that process looked like was, for lesser disputes, so disputes not about the Condo Act itself, for disputes about your declaration, bylaws, or rules,
yeah,
you could go to mediation. And mediation is sort of an informal process where a neutral third party attempts to help the disputing parties reach a resolution.
Right.
And if a settlement can't be reached in that, then you could arbitrate,
right,
which is similar to a court process, except the parties decide on who the arbitrator is going to be.
Right.
Now, of course,
again, lawyers
involved.
Yeah.
Also, can be a very expensive process.
Right.
So the provincial government saw that, you know, a vast majority of disputes between condo corporations and unit owners, or between unit owners, were about what we've been saying for a number of years at CCI, which is people, pets, and parking.
Yes.
So the legislature created the Condominium Authority of Ontario,
yeah,
which had one of its mandates is the governance of the Condominium Authority Tribunal. CAT. Yep. So that's how we get to that. And
that's a long lawyerly way to get to.
It's a long lawyerly way to get there. I'm also I did my undergrad in history.
Oh, okay.
So I like
to set the tone.
Stage,
Got it.
Set the stage.
Got it.
So
okay. So that's how we end up to get to CAT.
Yep. So CAT originally started with just resolving disputes about access to condominium records.
Okay. So hold on a sec. Now let me back up.
Yeah.
So you've got the Condominium Act, which then had a whole bunch of changes made to it. Then the Condominium Authority of Ontario came in to kind of oversee the condo business, for lack of a better term.
Yeah.
They oversee because it was desperately needing some kind of governance.
Yeah.
And you know, we can get into the stories. That's another podcast. Getting into the stories of the nightmares of, you know, property managers and building boards leaving with money and all of that stuff,
yeah,
right? So that's what the CAO is for. CAO, Condo Authority of Ontario.
It's also a great resource for people.
Yeah. So then the CAT is part of the CAO.
That's correct.
Who makes up the CAT?
So the CAT is made up of appointed adjudicators.
By whom?
By the CAO.
So the CAO has got a bunch of people sitting on top.
Yeah.
And they're going to appoint the CAT.
Yeah.
And people want, okay.
Exactly.
And who are sitting at the top of the CAO?
They are
lawyers. I bet you they're lawyers.
Oh no, some of them are not all of them are lawyers. No.
So who's sitting on the CAO? I just want to. I'm trying to get some context because the CAO sits up. To me, it's like a judge's chamber, right? They sit up here and they go, okay, you, and you're now part of the tribunal.
Right.
What are the qualifications? Do they all have some kind of qualifications to be able to say yes, that person's going to be a good asset for negotiating or mediating any difficulties, or are they just going, hey, you off the street there, you can be here because there's nobody else to fill the role? That's what I'm trying to.
That's a great question.
Ascertain.
So the people who are appointed to the tribunal, so the adjudicative members, have a history. They either have a legal background as a lawyer or an arbitrator, or they have a background in mediation and dispute resolution.
Okay, but do they have a background in mediation and dispute arbitration in condominiums or in anything?
Not necessarily condominiums, but usually.
Okay.
Yeah.
Interesting. All right, I did not know this. This is very interesting to me. Okay, so now you're appointed to the CAT.
Right, you're appointed to the CAT, and
so
when you're appointed to the CAT, you're a neutral third party who makes a decision. So the tribunal is a legal dispute resolution body.
Yeah.
It has the powers conferred on it under the Condominium Act to make binding decisions about the various disputes that are within its jurisdiction.
So once the tribunal makes a decision, that's it. It's final?
Yep, so a tribunal's decision is final and binding.
Okay.
However, there are, of course, recourses to the courts if you need to. So that's called a right of appeal.
Okay.
So if a party who is the subject of a final and binding dispute decision from the tribunal, if they believe there's been an error in law in that decision, they can apply to what's called the divisional court to have the court review that decision.
And now you're taking that's to the next level. So
that's to the next
okay,
level.
let's start at the beginning. So I have a dispute. My dispute is as a condo owner, the person above me is partying all night. Every day there's parties going on, a bunch of students up there having a great old time. I can't sleep. I'm a nurse, I work nights, I can't sleep. So now what? So now I go to my board of directors or my condominium property manager and I say, this has to stop, and I document all the craziness that's happening. So dates, times, all of that stuff. Now what do? I bring it to my property manager and she brings it or he brings it to the board of directors. Now what happens? I'm not getting any resolve. What happens?
That's a great question, and it's going to have a long answer, but I'll try.
Go ahead. Go for it. I'm going to sit back. I got my drink here, and
a good thing I brought an iced tea. So I think before I dive into that, I think it's important to outline what kinds of disputes the CAT can actually resolve.
That's a good point, because it's not everything.
It's not everything. It has a very limited jurisdiction.
And why is that?
Basically, the legislature wanted to make a forum that was easier to access than the courts for the most common condominium disputes.
Noises, parking.
Right. So the things that are in the jurisdiction of the CAT are records, of course, which was their original jurisdiction. Right. Pets or animals, parking or vehicles, storage, and now it's expanded. So as of New Year's Day of 2022 of this year, it expanded to include noise and nuisance, smoke and odors.
Interesting.
And then a few.
Good luck with that one.
Yeah, it's difficult to assess sometimes. And of course, smoke. I said smoke. So vibration and light. Surprisingly, light. I don't know what
vibration and light.
Yeah. Before, I don't know what a light dispute would be, but I actually got a case here.
Oh, we're going to talk about that one. Hold on, let me write that down. Light dispute. Hold on, I want to hear about that one. Okay, so those are kind of the general things that the tribunal will hear or address.
Right. For items outside of those matters, you still have either the mediation arbitration provisions, which I discussed at the beginning, or recourse to the courts.
Okay.
So, but we'll focus on what the CAT can resolve.
Okay.
Right.
So let's go back to my noise example.
Your noise example.
So I've done everything I can. The board's done everything they can. The party's still going on. Now what?
Now what? So the first thing to look at is, of course, your declaration, bylaws, and rules.
Right.
Most condominiums have, either a provision in their declaration or a provision in their rules which talk about unreasonable levels of noise
Right.
and nuisance. Right. So, say you're a unit owner, Michelle, and you have an issue with your upstairs neighbor partying.
Oh yeah, they're
right?
partying. They're playing Linkin Park, and I can't.
They're
stand
playing Linkin Park and other scream music.
Yeah, that's right.
Yeah. So you've reported it to your property manager. You've documented the situation.
Yeah.
The property manager takes it to the board of directors. Board of directors wants to know what to do. So under the Condominium Act, condos through their board of directors actually have an obligation to take all reasonable steps to ensure that the owners comply with those.
Right.
And the owners, of course, have a corresponding duty to comply. These are both provisions of the Condominium Act.
Yeah.
Yeah. So, they're required to take reasonable steps, not necessarily every step. So what we have to determine what is reasonable. Usually what is reasonable is, send a letter to the owner who's partying from the condo. Listen, thanks, we've got some complaints about your partying. Partying's late at night, it's disturbing your neighbors. Keep it down, thanks.
Yeah.
90% of the time, that settles the matter.
Usually.
Yeah.
Yeah.
And but the other 10% of the time it doesn't.
No.
And
it makes it worse.
it could make it worse. Owner.
Now they're playing Metallica and Linkin Park
At the same time,
at the same
competing.
time.
Or how dare they send me a letter telling me about my music? Now I'm going to hook up some big subwoofers, and not only is the music loud, but I'm going to shake all the units below me.
That's right.
So that clearly doesn't work. Usually the next step after, a couple of notices from the condo is, maybe we need to get our condo's solicitor involved.
So that's when the lawyer steps in.
That's when the lawyer steps in.
Yeah.
Lawyer sends a couple of letters,
Yeah.
Thank you. Here are the provisions of the declaration you're violating. Here are the, the issues that we're dealing with.
And usually they include some consequence. And once you reach that legal point, there's some kind of consequence that can be...
Well, so the consequences can be, look, when we the condo has taken its reasonable steps and tried to address the matter. The issue's continuing. Now we've had to escalate it to our lawyer, and that lawyer is going to inform the violating unit owner of, listen, there are going to be consequences if we go to a tribunal hearing, or if we go to mediation, or if we use one of the dispute resolution processes.
Right.
Again, 90% of that 10% where the lawyer gets involved, things are back to normal.
Yeah. That
Small percentage.
One little percentage.
Small
Yeah.
percentage doesn't comply, and the partying just continues.
Yeah.
So what do you do, right?
That's where I'm at. Yeah.
So what do you do? So now that we've established that the CAT exists to settle or to resolve these kind of disputes, we can bring an application to the condominium authority tribunal, and that will provide us, once we've gone through the process involved in the CAT system, which I can also talk about.
Yeah.
We can get a binding decision that's binding on both the condo corp and the unit owner, resolving that issue.
Okay. So let's talk about those steps.
Yeah.
So now, does the condominium solicitor bring it to the tribunal?
Yes. So a condo can bring its own application.
The board has to do that, though.
Yeah.
Or the property manager on behalf
Or
of the
the
board?
property
Okay.
manager can also do it. I do often caution sort of against that, or at least for boards to consider having legal representation in the tribunal, because although it is accessible and to board members directly and to property managers who can act for the condo on the matter, it is still a legal proceeding. It is a tribunal, an administrative tribunal, while not a judge, but still has powers to make final decisions, and those final decisions can also have cost consequences.
Right.
So if a condominium is unsuccessful in an application, for example, there could be potential cost consequences against the condominium corporation. And there's also a wide body of law about things like noise and nuisance, about pets and animals, about things like
There's
that.
also precedent. So
Right.
as a condominium owner, as a condominium board of directors, or even a property manager, you might not know all the precedent. It's the lawyer's job to know the precedent
Exactly.
set. Yeah.
Yeah.
Okay.
Just like I'm not an electrician or an engineer, I wouldn't give an opinion on what's wrong with the wiring in the building.
Right.
Just like somebody who does not necessarily have legal training can provide an opinion
Well,
on, of
and
course,
that's
the
true.
potential outcomes of a legal proceeding.
Right. Okay. So now you take it. So Chris Mendes, you are now representing the condominium corporation. I'm the unit owner. This has all come to light. You are now bringing it to the tribunal.
Yeah.
Step one. So you bring them all the documentation, I'm assuming, that you've collected, being declaration rules, bylaws, all the reports that the owner has given, all the letters you've written,
Yeah.
and you make one big giant file and you say, here, Mr. Tribunal man, here you go. Bang. Big thing on the table falls, breaks,
Not quite, but sort
But
of.
close.
But
All
close.
right. Okay.
So the CAT is broken down. So a tribunal hearing is broken down into sort of three distinct sections.
Yeah.
It starts with negotiation.
Okay. So stage one.
So stage one, negotiation, which is it all takes place online. The CAT is entirely online.
Online?
The first in Ontario.
Really?
Yep.
Okay, that I did not know.
It's entirely online and in writing. So there's in very limited circumstances is there ever a live.
Really?
Yeah. Yeah.
So you have to do everything in writing. So everything has to be typed out. Oh, that's a pain.
Everything is in writing. Although the system is
They know
quite
we have
good.
these things now called, microphones, phones. We could do it all Zoom, podcast. We're recording this podcast. Can
Exactly.
they not do the same? Because that's
I think
a
it
lot
will
of
evolve.
writing.
I think it will evolve to that in.
That's a
in the
lot of
future.
writing.
It can be.
And the corporation's paying a lawyer to do it at 2 minutes. $2,000 a minute of your time.
Well, I wish I'd retire next year.
But okay. So negotiation. So
So the negotiation is no member of the CAT is involved at that point.
Okay.
However, the CAT provides you with a forum, which is the online forum so the parties can attempt to resolve that dispute.
So it's like a forum type.
Yeah.
You type in the forum.
Yeah, it's sort of like a chat room.
Oh, okay, gotcha.
Yeah,
Okay,
exactly.
got it.
It's exactly
Okay.
like a chat room.
Okay. So now you're chatting. You represent the condominium corporation, who's trying to get rid of this noise. So who's on the other side? You would assume that the owner that's causing the noise and their solicitor would be on the other side of
Correct.
this. Okay.
Yeah. So this is the stage one, or the negotiation, sort of represents the final chance to resolve the dispute before a third party becomes involved.
Okay.
So if the parties can't reach a settlement or an agreement, a resolution of their issues in stage one, we move to stage two.
Okay. Stop.
Yeah.
Stage one. The condominium corporation, the noise thing. Because that's the example that we're using. So, dude on the other side says, "Yeah, I'm going to stop the noise." Okay, and he doesn't. Does this keep going, or do I have to refile
That's a good question.
another complaint?
So let's say you, in stage one, you come up with an agreement with the
Yeah.
the partier, and the partier says, "Okay, no, or I'm going to stop the noise. I'm going to stop partying. I apologize for disturbing my neighbors." At that point, the CAT's online system will generate what's called a settlement agreement.
Oh, interesting.
Yeah.
Okay.
And that each party will sign the settlement agreement,
Okay.
and then it becomes it's binding on both parties.
Okay. So
Right.
dude doesn't stop.
Yeah, and there's actually dude doesn't stop.
Yeah.
Partying continues.
Yeah.
The CAT actually has jurisdiction also to resolve disputes where there's been a settlement agreement and one party is not following that settlement agreement.
Okay. So
Yeah.
I could go back.
Yeah, so
is
there's
there a case like that?
Very
Yeah.
recent case, actually.
Okay,
I
let's
picked
talk
it up
about
this
that.
morning. So what this case was about was records. And I've got some of my notes here. As a typical lawyer, I write everything down.
Oh my goodness. Look at that.
So this was the
Can you
case.
see that? Can you see all the notes? Yeah, it's like pages and pages. He killed a tree.
No, don't say that. It's made from recycled paper.
There you go.
Oh, yeah.
All right, talk to me.
The
Okay.
case is actually called Raymond versus Leeds Condominium Corporation.
Okay.
Interesting case. Parties had a dispute about records.
Okay.
So this didn't settle in the negotiation stage, but settled in stage two.
Okay.
So
Stage two is
it's
what?
the mediation.
Got it.
So in the mediation, the parties reached an agreement about their records
Okay.
issue. However, one of the conditions of the settlement agreement was that the parties keep the terms of the settlement agreement confidential.
Okay.
Right? So That's typical, and so
Yeah.
everything that happens in mediation, of course, is subject to confidentiality.
Yeah.
Right? And what we call like mediation or settlement privilege. So it's not to be shared with other people.
Right.
So the board of the condo in this case had, of course, incurred some costs in reaching that agreement.
Right.
And when they sent the quarterly financial statements to the unit owners,
Oh, no.
they accompanied it with a letter explaining the increase in common expenses was due to a CAT case that they had with an owner, that the CAT case was about records, and that the records had been provided. Now,
Oh, no.
the unit owner in this case thought that, okay, wow, they've just breached the confidentiality provisions of the settlement agreement by sending this notice along with
Did it have names in it?
so this is where the condo was actually successful in this application, or in defending this application. But because there was a settlement agreement
Yeah.
generated by the CAT and of course
Yeah.
agreed to by both parties, allegations of breach of that agreement fall within the CAT's jurisdiction. So,
Okay.
Yep. So the
So you have to
unit
go
owner,
back into the CAT and redo a whole thing saying they breached the mediation or they breached the stage or they breached the whatever we negotiated or
Right.
the settlement agreement. Yeah.
Right. So the unit owner commenced an application to enforce the confidentiality provisions of the agreement they had reached.
Right.
Now it went to a hearing,
Okay.
and the tribunal said basically, yes, they sent a notice. However, the notice did not make explicit reference to the settlement agreement and contained only general terms about what the CAT is
Okay.
and that there was a case. Now, they cautioned. They said, you're getting very close.
Like you're teetering that line.
You're very close to
breach.
to breaching that confidentiality.
But was the name of the owner involved? Was the unit number in there? Was any of that
No, it
privacy?
wasn't. And it's a good thing you asked. So not only does the settlement agreements have to remain confidential, but actually Section 55 of the Condo Act,
Yes.
which is the records provision,
Yes.
sub 4, sub 1, actually prohibits condominiums from disclosing information about particular units or particular
That's
unit
right.
owners.
Yeah.
Now, although the condo was found not to have breached the confidentiality provisions in this particular case, in Raymond versus Leeds, CC number 8, the CAT cautioned. You got to be very careful when you're sending out a notice to the unit owners about
The CAT case.
about the CAT or about
Yeah.
a settlement agreement that's been reached. So, while communication with the owners is important, we do kind of have to do a balancing act of what needs to be kept confidential and what can be disclosed. So, important to kind of seek, if you're a condo board and or a property manager and you're writing a letter to the owners about the
Costs,
finances,
yeah.
about costs, run it by your condo's lawyer first. Make sure you're not.
That's a good idea.
Yeah,
Make sure you're not breaching,
make sure you're not
or
breaching
you're not
the terms of the
close.
settlement.
Or you're close enough to the line but didn't cross it that you might be able to get away
Right,
with it.
right.
How do you know they didn't go to the lawyer and the lawyer said, you're okay?
Well, we don't know that. It wasn't me.
Like a plausible deniability every time.
So
Okay.
certainly that's just to circle back to your question.
Yeah.
You've reached an agreement in the negotiation stage or mediation stage, and you have CAT generates a settlement agreement. That should end the matter. Both parties can abide by that settlement agreement.
Yeah.
Also have recourse back to the tribunal if there's a breach.
Okay, so your negotiation settlement done. What if the one party says, no, you know what, this negotiation isn't what I'm looking for. I'm not willing to let him play death metal at until midnight. No, I don't want this
Yeah.
noise. How do we? So then we go into what we had just talked about, mediation.
Right. So mediation
what's
is
that?
stage 2.
Okay, so are we still online for this?
We're still online.
How?
So it's like a chat room.
Okay.
It's a whole online platform. So you go to the CAT's website.
Yeah.
It has a tribunal link. You can the link for the tribunal's homepage has like file an application, respond to an application, various things like that.
Okay.
And then you log in, you put in all your information, and it's basically a series of chat boxes.
Okay.
Yeah. So when you get to, there's also an online portion where you can upload the evidence you're going to be relying on.
Okay.
So you haven't settled in stage 1, but we go to stage 2.
Right.
Stage 2, the CAT actually appoints a mediator.
Okay, so now we have a person.
Now we have a person.
Okay.
Also still online.
Okay.
Yeah. Also still in
Like,
writing.
really?
Yeah.
I'm not liking this. Okay.
It actually works much smoother than
But you're not.
than you would anticipate.
But you're not getting. To me, when you're in mediation and arbitration, my experience in those kind of houses is you can tell a lot by a person's physical being.
I agree.
So how do you mediate when you can't, when it's all in writing? You can't read tone in an email. You can't read tone in the chat. You can't read anybody's face in order to see. And I'm not suggesting by any stretch of the imagination that everybody's good at reading people, but there are certain cues, and especially if you're an experienced mediator or arbitrator, that will give you indications where they're like, I don't think this guy's going to really do what he says he's going to do here. How do you do that over a chat room?
Yeah, it can
without
be quite
being
difficult.
live. So, okay.
I think the trade-off there is
Expediency by the sounds of it.
it's expediency.
Yeah.
Cost. You don't have a mediator there present all the time.
But the mediator, if they're on the other side of that, is there not a cost?
Not to the users. So the users pay a fee to access the CAT. So there's the exact number slipped by
Was there $250?
Yeah. So if you went all the way to the end,
okay,
somebody would have paid $200 to access the system.
From A to Z.
From negotiation to a tribunal hearing. So very accessible.
I'm sorry, that seems really cheap too. Okay, so but then you've got to pay lawyer fees. So let's just, yeah, well, true. Then you got to pay lawyer fees, or you have to pay, whatever property manager for their time outside of their contracted, what their contract says. So
yeah. So while it is accessible at a lower price, the cost can be very similar.
Yeah. Okay.
We often, in my opinion, they often are very similar to what a condo could expect to in a small claims court.
Yeah, exactly. Okay, so now you've got this mediator. They've been assigned. So Joe Blow's been assigned to this case. We can use our noise case as an example. And so now you're filling out all these boxes. And what are you telling them in these boxes?
Yeah, so the mediator who's a neutral third party, will look at the evidence. So if the condo is the applicant, so we're trying to get unit owner Michelle from having your parties at 2 a.m.
right
to stop. So we're going to upload what we're going to rely on. So the evidence we're going to rely on. So the complaints received, things like that. There is some evidence issues which I can get to after. And then the mediator will look at that and attempt to negotiate with the parties so that they can agree on a situation. And often what that incurs is, the mediator will explain the potential consequences of a tribunal decision, the benefits of reaching a settlement before a decision is imposed on the parties. Mediation is beneficial because the parties can sort of reach a resolution that may not necessarily be ordered by the tribunal, and can create a situation that may be more flexible and more workable.
Well, and probably more collaborative.
Definitely more collaborative.
Like the negotiation side would have been the way to go because it's collaborative on both sides.
Right.
But somebody didn't like something, so then it goes to mediation. But you're still in that collaborative.
You're in a collaborative environment, but you're being guided by
someone that can direct
with settlement experience.
Right. There you go.
With experience in resolving disputes.
Right.
Often, sometimes, more often than not, the issue is not an underlying issue is, more often than not, the overt issue is the noise, but there's often an underlying personality conflict.
Oh, usually. Yeah, usually there's something more going on.
And mediators can often assist in, getting past the stuff on the surface and helping the parties reach the core of their dispute before a decision is imposed on them.
That's right. Okay, right. And that is when the final stage. So if the negotiation didn't work and stage 2 didn't work, mediation didn't work, now we're in the final stage.
Now we're in the final stage.
Which
so
is
it should is a tribunal hearing. So it should be. I'll first note. So the mediator cannot make a final decision that's binding on the parties. So I will note that.
Okay.
Right. So
they can suggest.
They can
and you
suggest.
can do a settlement agreement again.
And they can put together a settlement agreement, but they can't.
But they can't say this must be done.
Right.
Got it.
So let's say the parties don't resolve in mediation. The next stage is a tribunal hearing. which is a hearing, again in writing.
In writing?
In writing. Although
That's weird.
There are the CAT's rules, so the rules of practice which guide how the tribunal works, do permit a tribunal member to, can conduct certain things over the phone or over Zoom or things. So the CAT can really control its process.
Okay.
Yep. So in writing.
And now we're going to, at this point in time, wouldn't the person on the other side be like, okay, this is getting ridiculous? Like, okay, you're gonna fill out all the boxes again? And like, how do you...
Yep.
So now you click hearing, and you have to fill out everything again.
Right. So the hearing is a legal proceeding.
Okay.
Right. So it's more formal than the mediation and the negotiation.
But it's still in writing.
But it's still in writing. But there are rules of evidence. There are witnesses. There are cross-examination of those witnesses
in writing.
In writing.
How do you do that?
It's a skill. It's a skill. It's a skill about.
Like what to ask,
persuasive writing,
and
presenting the evidence in an appropriate manner, and putting together, the case law and the precedents that you're going to rely on, and constructing the evidence that you're going to rely on too.
So you know what though, as I'm thinking about this whole process, it because it's in writing, it does take out the emotion.
It does.
Interesting. Oh, I think I'm going to be one of those lawyers. Because that's my problems. I'm so emotional about all this stuff.
There's very unlikely to be a Tom Cruise, Jack Nicholson moment. So you can't handle the truth.
That's right.
Yeah.
Interesting. Okay, so now we're in the final stage. So you're back and forth again. So you're presenting all the evidence again. Now, is the mediator involved? Is that same person involved? Or now this is going to a tribunal hearing? So are there more people that are now looking at the evidence? Or is it just one person? Or how does that work?
Great question. So mediation, as we talked about with the Leeds case, of course, is subject to confidentiality.
Correct.
So everything discussed in mediation and proposed settlements are confidential between the parties.
Right.
And you cannot use those settlement offers or information provided in mediation in the tribunal hearing. So,
what?
So the tribunal hearing is a legal proceeding.
I know, I get it.
To make a final decision based on the evidence that you can present. So,
but part of the evidence that I'm presenting is that we went to mediation and the guy is still playing Metallica and death metal at 2:00 in the morning every morning.
Right. So we have that evidence of the Metallica being played at 2:00 in the morning, and that will be our evidence in the tribunal.
So can you continue to gather evidence throughout this whole process?
Yes, you can.
Ah. Okay.
Yeah.
All right.
There are very limited disclosure provisions in the rules of the CAT. So you present your evidence that what you had through your witnesses.
Yeah. So now you have witnesses. Okay.
Yeah, you have
so
witnesses.
who would you gather as witnesses then? So let's take the example of me and the people upstairs playing death metal at 2:00 in the morning. So who would be my witness? Would be could you call upon other condo owners in
Yep. So I would ask the people who are complaining about it,
okay,
to be witnesses to testify to their experiences.
And are their names presented and shown to the opposing party?
If they wish to be a witness, then yes.
Interesting.
Often the property manager is the best person to be a witness because they've received the complaints. They've got the audio recordings. They've got the
times that it
happened, the potential sound tests that were done.
Yeah. That's crazy though. That's crazy that all of that